His Excellency William Samoei Ruto, President of the Republic of Kenya, the Deputy President, Honorable Professor Kithure Kindiki, the Honorable Chief Justice of the Republic of Kenya, Lady Justice Martha Koome, Honorable Chief Justices of various jurisdictions, Deputy Chief Justice Lady Justice Philomena Mwilu, Prime Cabinet Secretary Musalia Mudavadi, the Governor of Nairobi County, brothers and sisters, judges, distinguished guests, ladies and gentlemen. It is my honor and privilege to welcome you all to the Supreme Court at 12 Jurisprudential Conference. In early March this year, the judges of the Supreme Court of Kenya, during our annual retreat, realized that the time has come for us to engage the Kenyan public, including ordinary Kenyans, civil society groups, members of the bench, members of the bar and academia, as well as state actors who are affected by our decisions in their work and in their lives. We also determined that we would engage our colleagues in other apex courts, both in the African region and globally, to assess our progress as a court and to ensure we remain on course as guardians of the Constitution. It has always been the rule of thumb, however, globally, that judges speak only through their judgments. However, in the contemporary world, judges often find themselves under intense scrutiny and criticism without a chance to respond or engage, even to clarify, if need be, the reasoning of their decisions. Traditionally, judges have had no platform from which to speak apart from the courtroom, from where, in an adversarial system of justice, at least one party leaves unhappy. This conference is therefore conceived by the desire to demystify the court's role and processes and to correct misconceptions about its mandate by deepening public understanding of the court. While judges are not infallible, in a democratic space, the public need to be afforded structured engagement where, from time to time, they can learn about what judges do, where they sit, when and how they do their work, and most importantly, why they do it. This is the reason we are all here today, and this week, to share, to engage, to learn, and to reflect. Your Excellency, allow me briefly to reminisce on the history of our Constitution and in particular the evolution of the independence of the judiciary. Kenya's constitutional journey to date has been a fairly long and tedious process, from the Independence Constitution and to numerous amendments to it in 1964, and many from 1969 to 1991, and later in 1997. Many of those early amendments, particularly those before 1991, changed the character and tenor of the Constitution. Judiciary estimates were considered not independently, but we were considered a department, like the Office of the Attorney General. The security of tenure of judges was removed, drastically and adversely affecting judicial outcomes, with judges being appointed and dismissed at will by the President, and calls would come in at night from political actors directing what judges should do the next day. These were dark times indeed. Thankfully, this is no longer the case. By 1990, Kenyans were demanding for change, including opening up of democratic space, respect for human rights, accountable state institutions, and independence of judges. Comprehensive constitutional review, however, only began in 2000 with the appointment of the Commission, the Constitution of Kenya Review Commission, of which my brother Isaac Lenaola was a commissioner. That commission worked on a draft bill that was subject matter to the Constitutional Conference at Bomas of Kenya. Your Excellency, you will recall that in 2003, you were a member of the Parliamentary Select Committee on the Constitution. I believe that is where you and I first made acquaintance. And as members of Parliament, we were both delegates at the Bomas Conference, which adopted the CKRC draft bill in 2004. It is the CKRC draft that first made provision for Supreme Court. Similar provisions were contained in the document that went to referendum in 2005, but failed to meet the required threshold and was rejected. Kenya then went into the 2007 election without a popularly adopted constitutional framework, and as a result, in part, the election of 2007 precipitated a political crisis as never been seen before. As part of the resolution of the peace process that followed, the Committee of Experts on Constitutional Review, of which I was a member, was appointed to harmonize all the previous bills and drafts and to seek the views of Kenyans on contentious issues. And as a result, the Constitution of Kenya 2010 was adopted by Kenyans through referendum. This Supreme Court was birthed by that Constitution, born out of the people's vision for an apex court that would stand as the ultimate guardian of the Constitution and as an impartial arbiter for the nation's most difficult legal challenges. The Constitution gives the court original jurisdiction relating to any challenge of a presidential election result, an advisory opinion to be given to government, an appeal from a judge that has been removed from office, and any challenge on the validity of the declaration of a state of emergency. Of these four original jurisdictions, Your Excellency, the only one we have never invoked is the one relating to a state of emergency. In addition, the court is bestowed with appellate jurisdiction to hear any appeals on the interpretation and application of the Constitution, and also in the instance where an appeal is a matter of general public importance. The inaugural bench of 7 judges of the Supreme Court were appointed in June 2011. I was one of them. 2 others, Justice Mohammed Ibrahim, Justice Smoking Wanjala, are also still in office. We were later joined in order of appointment date by DCJ Rawal, CJ Maraga, DCJ Mwilu, Justice Lenaula, CJ Kome, and Justice Ouko. At this time, CJ Mutunga, DCJ Baraza, DCJ Rawal, Justice Philip Tunoi, Justice J.B. Ojwang have since retired. But going back to that inaugural bench, there were many challenges setting up a new court. When we first came here to report on duty, we found, as a totally new court, there were no offices for us to sit in, other than that of the Chief Justice, because even the Deputy Chief Justice was new. So we sat here and had a cup of tea in the CJ's office, and then we were asked to go home to wait until we were allocated temporary offices, a skeleton staff, and a courtroom. We had no rules of procedure, we had no practice directions, but there were already matters filed before us to get to work. And that we did. Over the last 12, now actually 13 years, the court has stood firm in its mandate, consistently asserting the principles of constitutional supremacy, sovereignty of the people of Kenya, and judicial independence. Challenges still, however, remain with regard to the principle of separation of powers, which guarantees judicial independence, particularly with regard to funding the judiciary as an equal arm of government, the attacks on judicial officers, and refusal to obey court orders. There is need, therefore, for checks and balances between the 3 arms of government without overreach or interference. Comity of the 3 arms of government is a cornerstone of our Constitution. Mutual respect is a necessary condition for the coexistence of the executive, legislature, and the judiciary, all who have one clear calling to serve the citizens of this great nation. Through landmark decisions, advisory opinions in moments of national impasse and precedents, we have strengthened our democratic foundation, and I believe the Supreme Court has continually sought to ensure that justice prevails for all Kenyans. This conference offers an invaluable opportunity to reflect deeply on the court's journey and to consider its impact and future direction of its jurisprudence. We will examine the paths paved by our decisions on critical issues, including presidential election disputes, constitutional questions, human rights, devolution, and so much more. The range of conference activities include public lectures, panel discussions, moot courts, interactive exhibitions, and stakeholder engagements, where we seek to enrich understanding and encourage dialogue about the future of the Supreme Court. As we embark on this conference, may our discussions be rich and enlightening. May they inspire fresh perspectives and reinforce our shared resolve in upholding the values enshrined in our Constitution. I thank you all and welcome you all once again to the Supreme Court at 12 conference. Allow me at this time to welcome to the platform the Honorable Musalia Mudavadi, Prime Cabinet Secretary, Ministry of Foreign and Diaspora Affairs, and the Acting Cabinet Secretary, Ministry of Interior, National Administration, His Excellency, Honorable Musalia Mudavadi. Welcome.